Back. We kick off the technical sessions today with the first one today on the due process enforcement, a session which is going to be very, very lively. Thank you very much. We have an absolutely distinguished panel. Honorable Justice Endlaw, thank you very much, sir, for accepting our kind invitation and agreeing to chair this session. Justice Endlaw is a renowned jurist. He has been a close friend of the bar. He is an unassuming, soft-spoken, but extremely hard-hitting when it comes to delivering judgments or holding forth in his court. It is very kind of you, sir, to accept our invitation because the topics that are going to be discussed here in this small bar association conference is really to do with how do we manage this entire sphere. It's a very important legislation, and we have processes, we've got issues in relation to, as any new entity or a regulatory body has. We also have with us Justice Mittal, who is also, to all of us who practice here, no stranger whatsoever, and we are glad to have him on board the CCI for obvious reasons, because as lawyers we recognize that an element of legal issues are always there and extremely important, and that gives us great confidence to have you, sir, on board. And thank you very much for accepting our invitation and to be here also. We have two extremely eminent practitioners of competition law. We have Mr. Manas Chaudhary, partner with Khaitan, and we have Mr. Percival Billy Moria, partner with Amarchand, Cyril Amarchand, who are here. In fact, he just he landed this morning, I think, Percy, did you not? Early this morning, and he sort of rolled over and joined us today. We have Dr. Christian Steinle, who's also joined us, an extremely valued and distinguished guest from international firm, who's also going to share his views on this important topic and how his experiences there help shape our views. With these words, may I hand over the proceedings to Honorable the Chairperson to conduct. Thank you so much, sir.
Good day, friends. Hi, good morning. My compliments to all of you, particularly to the Bar Association for this endeavor, and which I think is today the need of the hour. And though the format which has been devised for this session is slightly different from the take which I have on the session, but if I may just give a few opening words, contrary to what we discussed outside, I feel that a robust bar for any adjudicatory body is a must to enable that body to hand out the decisions, to hand out which it has been constituted. But that itself, what my experience with this law has shown, I would say a limited experience, because we get to deal with it only when the cases land up before us. So what I have seen till now is that nearly all the litigation which has come before me is on a procedural aspect. And during the hearing of those cases, the conundrum, as I said, I called it an adjudicatory body, which is resulting from this is that what is the nature of the commission? What is the nature of the commission? What is the nature of the appellate tribunal? Is it an adjudicatory body? Are we to follow the same practices which we follow before other courts and adjudicatory body? And whenever we say adjudicatory bodies, what comes to the mind of most of us who are ordinary practitioners of law in the courts is the courts. That is it to adjudicate and proceed like a court. And that is why my compliments again for this session, because according to me today, as far as the courts are concerned, the theme of this session is the most important theme compared to all the other suggestions, if I may, other sessions, if I may with respect say so. And why I say that is because procedure is something which distinguishes our jurisdiction from other jurisdictions. As far as the substantive law is concerned, the substantive law, I believe that the way the law is structured and the preceding law had been structured, the international precedents, I would say, and by and large, there is no problem in developing that law. But there is a lot of problem which all of us are facing, or rather I should say, this law is facing on the procedural aspect, and which maybe is resulting in the substantive law not taking off. It's all being mired in the procedural aspects, and which ultimately is leading to the inefficacy of the law. And if I may again, with respect, say that my fear is that it should not go down the MRTP Act way, which is, according to me, a very real fear. So that is why I said I have a slightly different take on the subject. So I suggest we'll now proceed the way the session has been structured, topic-wise. May I hand over to you?
So each topic. Thank you very much. I think next time I submit my photograph, I must smile a little bit. Trouble is I have chubby cheeks, so it sometimes doesn't come out too well. Some of these topics are, so there are about 5 topics. I think I'll just have very, very brief comments on each one. The first one, I think, is scope of inquiry and investigation. We have the DG who conducts the investigation and the inquiry, and then it moves on to the CCI. How often have I argued in the Compact about, the quality of the discourse, to say, well, the CCI just rubber stamped what the DG had to say, etc. As lawyers, we have to take these positions. I think it's fair to say that both the CCI as well as the DG has come a long way since the time it first started. Practices and procedures and processes have improved over time, which is as it should be, because it's a new law, everyone is learning, the bar as well as the bench is learning at this point. Just a few things on this particular topic. Stuff like expert witness reports that are produced by either party are sometimes dismissed. The jurisdiction regarding, when you can dismiss expert opinions is pretty clear. But one of them is surely not the fact that it is a report that you paid for. I think the independence of the expert cannot be questioned only on that ground. There are many other aspects that I'm sure others will touch upon. Global best practices, I think the CCI has come a long way in adopting some of these. We still haven't seen things like cooperative dawn raids. We've just had 2 dawn raids in any event, but you haven't seen stuff like cross-border cooperative dawn raids. It is something that will happen. I do know that the CCI is very deeply engaged with the ICN. There is a great amount of cooperation, and I think we are all looking forward to a potential ICN conference in Delhi next year. So, whereas, again, global best practices are being absorbed and followed, there are certain other aspects that keep coming up in every hearing that we do. Stuff like, there are no penalty guidelines. So these are the issues where almost every mature jurisdiction across the globe has penalty guidelines, and we should bring that in because it is a source of unnecessary controversy, and it's something that is so easily done. Dawn raids, we've just had 2. The first one has been challenged in the Delhi High Court. The warrant that was taken out was very limited in scope and purpose, and I think the Delhi High Court intervened in the matter. But again, talking about global best practices, I think it's important to point out that in EU, there are some very distinct guidelines on the dawn raid. So one cannot go beyond the scope of the warrant. And again, it's something that I think will happen over a period of time. Perhaps the experience with the very first dawn raid conducted will help in the process. But this is again something that we need to adopt international guidelines. Confidentiality, there's been a lot of concern about confidentiality. The feeling generally is that lawyers tend to push the envelope on confidentiality. I just want to say that if you look at the law, first of all, Section 57 is very much similar, if not identical, to Section 60 in the MRTP Act. And both the provisions really said no information, so all information that was procured from a party to the proceedings had to be confidential. So the law lays down a very broad standard which says that all information that any party will furnish is subject to confidentiality. Subject, of course, to anything that has to be done in accordance with the Act or any proceedings under the Act. So really, I think the criticism is not very fair because there is a regulation formed by the CCI where the bar is set much higher. Under the regulation, the information that on which confidentiality is claimed, and it's not an automatic process where anything that you submit is subject to confidentiality. It has to cause serious harm, for example, or it has to cause diminution in value of the information, the commercial value of the information. And it's only on these criteria that the CCI is, by its own regulation, is to grant confidentiality. There are also other situations. So, I would like to remind people that if one is a listed company, for example, SEBI guidelines on insider trading are very stringent as to what information a company can make public. So that's something that they have to keep in mind. And finally, under the Act itself, sharing of price-sensitive information or sharing of information regarding markets, sales prices could in fact be a violation because it could bring you within the ambit of, perhaps you could be accused of being, furthering the interests of a cartel. So these are the concerns on confidentiality. Business is very, very sensitive about confidentialities. In merger control, for example, a lot of the information submitted is highly confidential. So I don't think this is such a concern, and I don't know where this comes from. I think with this, I will pass on the mic, if not the baton, to whosoever the chairperson.
I think Justice Mittal said that he would be speaking on confidentiality. Yeah. So we can start with that.
Before I touch upon the issue of confidentiality, I will just make a brief comment on the start of investigation. In fact, investigation with the DG starts with the passing of the order under Section 26 of the Competition Act. And information is laid before the Competition Commission. Some section, either Section 3 or Section 4 or both the sections, may be mentioned by the informant, or maybe informant may not be aware of these sections. He may just skip those sections. So when an order under Section 26(1) is passed, the Commission may prima facie define the relevant market. Commission may say that there appears to be prima facie violation of Section 3(1), that be Section 3(3), and may order investigation into the matter. So we have to be mindful of the words used by the legislature in this regard. So CCI is ordering investigation into the matter. It would perhaps never mean that if there are no allegations of Section 4 and investigation has been ordered into the matter, then the DG cannot go into that aspect of the violation. There may be cases where there are allegations of Section 3 and Section 4 in the information, and the Commission applies its mind and finds that there doesn't appear to be any violation of Section 4, and there is only violation of Section 3, prima facie. Of course, in those cases, the DG cannot go beyond Section 3, and if he finds that there is some more material, which has come up before the DG, then obviously he will have to come back to the Commission, will put up that material to the Commission. Commission will be at liberty to apply its mind, and then allow the DG whether he will be in a position to look into that matter or not. So that is one part. The other thing is, as you all know, who are practicing on the competition law, the CCI has passed over 300 orders under Section 26(1). That is, out of more than 700 orders, total informations, where some of the information, in fact, majority were closed under Section 26(2). But in over 300 cases, the Commission applied its mind and ordered investigation. Sometimes these orders are also challenged before the High Court because these orders are not appealable. Order under Section 26(1) are not appealable. So far, to my knowledge, there is not even a single order which has been set aside by the High Court. But of course, the writ petitions are entertained, and not always, but many a times, either the investigation is stayed or some other order is passed. So that delays the investigation, and sometimes the purpose is lost. So it is for the enterprises to see whether it is in the interest of the enterprises to approach the High Court on these grounds, because again there are all check and balances. Because if DG is to investigate, then the report is to come before the Commission, and the Commission is to apply the mind. There are other things to be talked on the inquiry and investigation. One would be the right of cross-examination. Regulation 41, in fact, talks about the right of cross-examination. So, whenever any oral evidence is recorded by the DG, or for that matter by the Commission, the DG or the Commission has been empowered to allow cross-examination. But there is a rider that the DG feels or the Commission feels it necessary or expedient. So sometime it is thought that it is the discretion of the DG or the Commission to allow or not to allow the cross-examination. So this discretion is not an arbitrary discretion. Obviously, if any material has come and that material is to be used by the DG in the report, so obviously the cross-examination has to be allowed. But maybe that material is put to the party against whom that material has been produced, and that party either admits that material or does not dispute that material. Then there will be a question whether even in those cases the DG is obliged to ask the party or to allow the party cross-examination. It seems that the scheme of the Competition Act being a regulator doesn't envisage such a right. DG, or for that matter the Commission, is not a court. Evidence Act as such is not applicable. The Code of Civil Procedure is not applicable as such. Evidence Act, only limited provisions are applicable. CPC, only limited provisions with regard to summoning witnesses, etc. is applicable. So, to that extent, I think cross-examination can be allowed only when the material is specifically disputed. The DG can allow the cross-examination suo motu. He can allow on the application of the party. But obviously, the party will have to give the reasons for the purpose of cross-examination. As far as confidential information is concerned, as stated by Percy, Section 57 is the heart of the legislation. Of course, the scope as given in Regulation 35 and then Regulation 6 of the Lesser Penalty Regulation. Section 57 talks about that the information cannot be revealed except for the purpose of the Act and in accordance with the Act. Unless, of course, the person who gives the information waives the confidentiality. So, and then there is Regulation 35, which lays down how the confidentiality is to be claimed, what are the grounds. So, one view could be that as soon as the information is laid before the DG or before the Commission, of course, the DG will go into the information, and if confidentiality is claimed, this will be put in the sealed envelope, not to be shared with anybody. And then DG will, of course, keeping that confidential information in mind, proceed with the investigation, and then apply mind whether this information needs to be shared. Maybe he will have to talk to the person who has given the information that there are certain grounds because there is right of defense. And maybe for the purpose of furnishing the report, DG may have to confront certain part of the information to make up his mind whether this contravention is made out or not. Because if simply without this process, the DG goes into the question whether it's a trade secret or otherwise, in fact, this is my personal view, this is not the view of the Commission, but I do feel that this could be one of the procedure where these apprehensions about the secret, of course, many a time the information is very, very sensitive. At the same time, the information at some time has to be shared with the person who may be visited with very, very high penalties. Similarly, Regulation 6 of the Lesser Penalty Regulation talks about that the identity of the informant and the information given by the informant is to be kept confidential. But many a time it is felt that such an informant or petitioner who has come with a leniency petition would misuse this provision. He will give just a little information and will say that nothing is to be shared. Then perhaps no purpose is going to be served. So again, this will have to be gone into, but there is a rider. Because DG applies his mind, DG keeps the information in the sealed cover, then many of the party, they file a writ, approach the High Court, that we have been called, we have been summoned, but DG is not parting with the information to us. What we have to say? Because when the structure of the act is like this, that DG has seen the information, now he is proceeding with the information. So it is to be ultimately, application of mind has to be there, and then he has to form an opinion whether entire information, part of the information, whether in percentage, whether in ranges, is required to be shared. And we have also to keep in mind another important factor. So there is no prejudice because the DG will ultimately share. Now suppose there is some information which is very important to be shared with the person against whom the information is to be used. The report is submitted to the DG. The party can very well request the commission that there is an important information which is confidential, which should be shared. I am deprived of my right of defense, of course. When the penalties are so heavy and high, a person just cannot be condemned with the keeping the information close to the chest. But again, if you stall the investigation, if you don't permit the DG to investigate, then it is very difficult. So with the limited time, these are some of my thoughts which I wanted to share. Then if I get some more time, perhaps. So.
Justice Medela, I must say, I want to ask a lot of questions to you and bind you to the answers.
Yeah.
And I'm sure so do all the other
Yeah.
practitioners over here.
Yeah.
But maybe just remind ourselves that unless Mr. Srinivasan is ready to extend the lunch,
Yeah.
because we thought we'll have about half an hour for a general discussion. So going by that, we just have about 10 minutes left.
Yeah.
Maybe have your views about how you feel, Dr. Stanley, that these issues which we've discussed till now, how you have been tackling it.
Thank you very much. First of all, thank you very much for inviting me to this very distinguished conference. I feel very much honored. It's a unique format with having the regulator, having the court represented here. Thank you very much. Indian competition law and European competition law are very similar when it comes to substantive law, but you already mentioned the importance of procedural aspects. And I would like to illustrate this with one example. In 2007, the European Commission punished the cartel of manufacturers of gas-insulated switchgears. Our client paid almost 400 million euros in fine. There were parallel proceedings in other jurisdictions. And like many modern cartels, so to speak, this was largely paperless. The main piece of evidence were the witnesses, the individuals who participated. And under our EU procedural rules, there is unfortunately no right of cross-examination. You correctly you mentioned the importance of cross-examination. This was a perfect example. In the parallel proceedings in another jurisdiction in New Zealand, the main witness of the leniency applicant had to testify before court, was cross-examined, while in Luxembourg, before the European Court of Justice, there was no such witness hearing. And the outcome was pretty inconsistent. While in New Zealand, the High Court found that there were serious doubts as to the credibility of some of these statements from this main witness. Before the European Union courts, the judges said, no, there is no need to hear this person, and there are no doubts as to the credibility. So the outcome was totally opposite. We are struggling a lot with getting the right of cross-examination. I think it's very important to see that cartels tend to be more and more paperless because the employees are meanwhile trained in antitrust law. They are very much aware of what is illegal and what is allowed, and so they avoid creating a lot of written evidence. So the main piece of evidence in the future will become the employees of the leniency applicant, and therefore it's important that procedural law copes with this trend. We in Europe, in my view, are not a good model in that respect, so please try to avoid our deficiencies here. With regard to confidential information, if I may quickly add something, I'm coming from a jurisdiction, from Germany, where we have a very simple principle. Defense counsel gets access to everything in the authorities' file. There are no redactions, there are no deletions. If there are, that's illegal.
from that point of view, of course, I'm also struggling with our EU system here, where we have a very similar system, that there can be plenty of redactions, that there can be heavy disputes about the confidential nature of a specific information. I think in case of doubt, defense rights must prevail. Meanwhile, the European Commission is improving in this respect. They are currently revising their procedure here, and what they are already doing in some cases is, if there is dispute, they allow access to confidential information to outside counsel, so that outside counsel can substantiate reasons why this document should be made available. The document will not be physically handed over to outside counsel, but just for the purpose of substantiating why they need access to this document. This is a clear improvement, because before this new practice, the authority decided whether this document would be made available at all. And frankly speaking, against my jurisdictional background, I have to be very clear. It's not the task of the authority to decide whether a document is relevant to the defense or not. Thank you very much.
Thank you. Mr. Chaudhary, you would be speaking on this, or Mr. Billy Moria wanted to say quickly about cross-examination, if you will be touching another subject.
I'll just be talking about a couple of things which has just emanated from the discussion from the beginning. To my mind, as Chairperson had said, that substantive law and procedural law should actually have some connection. To my mind, that is the crucial issue here. If we see the 1991 post legislations which have been drafted in India, we have got a unique section in Competition Act that is called 36(1), which actually mandates the CCI to observe principle of natural justice. And to my mind, that is the end of discussion. If we are not giving an opportunity of being heard to the party, whether it is cross-examination, inspection of documents, or confidentiality, I think there is a scope to go to the High Court. Because there is no remedy in the CCI if we do not get an opportunity of being heard properly. That is the reason, most of the matters and the other substantive law, to my mind, in our jurisdiction is all orders of the Commission are not appealable before COMPAT, whereas every order of COMPAT is appealable before Supreme Court. Now, this is something, a legal dichotomy, but for this, I think we have got a lot of scope to go to the writ court. And for that matter, for example, there are several final orders of the CCI which are not appealable before COMPAT. A matter which is closed after the DG has found a breach of the opposite party, but CCI concluded it otherwise, the party is remediless, even does not have a first right of appeal. Similarly, if it is Section 42 order, there is no right of appeal in the COMPAT. Section 43A can be debatable. So these are substantive law which the procedural law cannot remedy. The other issue which I was just discussing before this session, that there is a substantive law of interim relief before the CCI, but the regulations have actually defeated the purpose of the interim relief. So these are some of the issues I think actually is the cardinal principle where we are finding the procedural law is actually overtaking the substantive law. And to my mind, that is cardinal principle that an opportunity of being heard has been mandated in the law, unlike any economic legislation post-91 that is missing. So I think that is what I think should be the point of discussion in my view.
Thank you, Mr. Chaudhary. Mr. Billy Moria, you wanted to say something?
Yes, very quickly.
Cross-examination bit only.
Yes, very quickly, and with the greatest of respect, there's been this recent trend in the CCI to say, do you deny this to be the case? And if you deny it, then and only then will you be allowed cross-examination. I think this is deeply flawed. We are talking here not just about a plain, simple, unidimensional fact. This is not a situation where did you commit the murder, yes or no. Not a large number of questions that come up and which have to be investigated are very complex. So, for example, it's not good enough to say, are you denying access to the to the market, to your competitors, because there is no yes or no answer. The point is, denial of access is decided based on certain market conduct. There may be a whole host of market conduct, and there may be some market conduct which can be explained and justified. I mean, the Act allows justification. So, if one is posed that question, there is no yes or no answer. So to say that, if you deny, then and only then you will be asked to do a cross is, I think, flawed. This is especially so because, you see, if you look at the way the DG conducts investigation, it's very similar to a lot of other investigative agencies. So, for example, the CBI. When you are investigated by any of these regulatory agencies, you are questioned, and you don't necessarily know what somebody else has said about the subject matter of investigation. So you may have a situation where the DG report, without cross-examination, there are two sets of answers. Somebody makes an allegation, somebody denies. Now the point is, how does the DG arrive at a conclusion? And moreover, how does the DG arrive at a conclusion without allowing the defending party to cross somebody who has said something, especially when there is no documentation on record to substantiate this? These are very serious, issues which, fold into the whole, topic of natural justice that Manas touched upon.
See, as far as I see these platforms, I feel this is not a platform where we are fortunate we have the presence of the practitioners of competition law, we have the presence of the commission, with the judicial member being over here, we have the presence of the DG. We are not to convince each other of our arguments that we always have an option. What I feel we should use this platform is to see that how we can work better, and that's what I said initially, that I have a slightly different take on the subject, and I feel there is as I said, it's a very important thing. So I'll read, contrary to I normally don't like to read, but I don't want to miss out anything. What I have jotted down is that there is a need to evolve the procedures mutually between the bar and the commission and the DG. We somehow have overlooked that aspect in spite of tribunalization having been introduced in the country. We continue to see these tribunals in forums as with the blinkers of a civil court or a criminal court, and we are always trying to convince each other or to get a ruling, take it to the highest court. And what has happened to the Arbitration Act 1996 is before all of us. If we continue with this, we cannot give the fillip to this competition law. And let's understand, if we are not able to do fillip, we may have a short-term gain as lawyers. But ultimately, if the commission fails to do what it was constituted to do, we may, as I said earlier, we may go the MRTP way. And I have been there when MRTP was constituted, and I have seen that what importance was given to that forum. The best of the lawyers were going over there. But by the end of it, it was reduced to a district court. The lawyers refused to take a brief to appear before the competition, before the MRTP. So it's ultimately the bar which will be the loser. So we don't have to take an adversarial stand in the procedural matters before these forums. And this is, I'll tell you an incident in a shortest way I can. As a young lawyer, when I didn't have any work, I went with an aunt of mine in Noida who was buying a house. And naturally, I went all prepared with the books and all before the registrar, because I had guided her to pay less stamp duty. The registrar said, no, I wanted to show him the books. He said, forget it, I'm sending it to the collector. He impounded it. And that proceedings before collector went on. Collector of stamps used to sit in Ghaziabad. They went on for about 5 or 6 years. By that time, I started getting my own work. But because of my aunt, I had to go personally every time. And fortunately, towards the end, I think last 2 or 3 hearings, there was a very fine young collector. He used to be the district magistrate also. So one day he also got tired because he had so many things. He would call me at 6 o'clock in the evening. Then finally he said that, look, the deficiency is of 20,000. Without going into all this, I have a power of waiving it to 10,000. So if you want, I'll finish it today. You won't have to come again. I see you've been coming for so many days. Then I said, okay, I readily agreed. Then he said, but there is a catch. If I do 10,000, then my order is appealable. Then I cannot hand over the document to you. But if you pay 20,000, then I can hand over the document also to you. Fortunately, I was carrying it in my pocket. He sent somebody to the registry on the ground floor, the collection office. The money was paid. So 6 years I spent in going to Ghaziabad. I feel that's the kind of an approach. See, the collector used to sit in his office. These commissions, DG, they sit in courtroom-like atmospheres. But that does not mean that we treat it as a courtroom. And we have to understand, see, what is the fear? Why did this provision against cross-examination came in so many statutes? It's not only in this statute, in a large number of other statutes. The fear in the authorities is that the lawyers lengthen cross-examination to such an extent that there is no end to the proceeding, there is no end to the investigation. And that is the genesis of the creation of these forums. Otherwise, all these laws could have been, and ultimately they are dealt with in the High Court and the Supreme Court. So if we want, as I said, our attempt should be to see that we move towards the substantive decision on merits on all these issues and cut short the procedures. And we have to work in league with the DG and this, and they have to be open-minded to understand that, look, cross-examination is undoubtedly an essential part. In 26 years of law practice, I have not done anything else except evidence. I was not coming to the High Courts, to the Supreme Court. I was largely practicing in the district court or the forums where the evidence was the main thing to be done. And the most truthful of the witness, if you put him in the witness box without guiding him, his statement, when you read it on paper, will not appear to be untrue, even if he said that. That's how we don't still use the system of the entire thing being recorded, even if it was being, what is it called? Not teleprompter, that thing which, yes. So we don't use that, and even if we were to use that, nobody would have the time, because all of us are very verbose. So the script which comes out, no judge will have time to read it, the whole thing. So we have to, if we have to satisfy, we should analyze and we should tell the district, the Director General or the Commission. In fact, there is a difference in stand whether after the Director General has finished, whether before the Commission there is to be a fresh trial or not. In some matters, a concession has been given, but it's not very clear. So if we convince him that, look, why are you so afraid of cross-examination? And Mr. Billy Moria is absolutely right that without cross-examination, the truth can't emerge. The whole system is devised in such a way that it has to be three people who are working towards inquisitorial. Unfortunately, all our systems remain adversarial till now. So I feel that if we can evolve a consensus on this kind of a thing and build faith so that we move to decision of the real disputes, which we are not getting to in most of the cases. Because everybody, and we have to see, the litigants, when they come to you, they are totally guided by you. And you have to tell them that, look, we'll work it in this way, we'll give this proposal, we'll make this much disclosure. What they want to know is this is contained in this document, this is how we'll work it. And I'm sure over a period of time. So that kind of effort, according to me, should be made. And for that, see, if we have to continue to have a bar which is practicing in all laws and in all forums, and especially before the courts also, this kind of a thing will never develop, because it's very difficult to change from that. In a suit side, you are arguing that no, natural justice is this. You go to Competition Commission, you argue something else, your arguments. So that's why the need for a specialist bar. What is being said about the arbitration law, that arbitration in India is not kicking up because we don't have a specialist arbitration bar. The same lawyers who are doing trials in the courts are going at 5 o'clock to the arbitrators. So they continue to do the trials in the same way. So the arbitrations are decided in the same way as the suit. So that was what I felt. And the commission has to understand that in India we perceive, sir, any notice you issue, we don't understand it as an inquiry. A notice is perceived as a harassment. And this became quite evident when these government advertisements and banks advertisement were coming for this 500 and 1,000 rupee note. One of the advertisements in one of the newspapers of the government said that if you deposit till 2.5 lakhs, we won't harass you. So that means they are accepting that if they investigate, they will be harassing. So you have to understand the Indian psyche. That's why I said the Indian procedures are different. That Indian mindset is different. We have evolved natural justice to an extent which at least limited study I have done of other jurisdictions, none has evolved. The Indian Supreme Court is a leader in natural justice today. So natural justice is all very good, but it has to be within the confines of that subject. If it goes to an unlimited extent, then the whole natural justice loses its sense.
In fact, I will have a brief comment on this. So, the Commission had the occasion to see many cases practically, and most of the lawyers who are sitting here, they are aware as to what are the instances before the Competition Commission. Mr. Ramji and other persons, we had lot of discussions during inquiry before the Commission. First of all, as per the Competition Act, there is no provision that the DG has to follow the principles of natural justice. That doesn't mean that he has not to act fairly. He has to act because DG being an instrumentality of state, he has to act fairly. Secondly, a large number of cases, many of the lawyers sitting here would be aware, in a cartel case, there are three evidences. I quote from, not from a particular case, but generally, that there are parties A, B, C, D. They have talked to each other couple of days before submission of the bid. So there is evidence of call details, which is available with the DG. Second is that they submitted the bid on a particular date in the close vicinity of the time, and all those A, B, C, D met each other in the room where the bids were to be submitted. And then the third aspect is that the price is just identical. All these things are put by the DG to these persons, and they admit this. Obviously, DG would ask the talk what you had the talk with the other persons, and they are unable to say, or they may say that we are known to each other, we are friends. Therefore, we talked about our friendship, we talked about our dinner and other things. Perhaps no evidence can come on that. So the question will be, each and every advocate would be aware as to what are the contents. What are the contents of the case? What are the contents of the deposition? And if the participant of the cartel has admitted all these things and he said that he would like to cross-examine the other person. So obviously, the other parties, that if, say, DG has not allowed the cross-examination, then obviously the commission is there. And in fact, in many cases, the commission has allowed cross-examination, where it was denied by the DG. And in one of the case, the party could not make out a case for cross-examination, but while passing order, commission came to know that it's a case where this particular thing ought to have been put to the particular party. So the lawyers who were there in that case, so instead of passing the order, commission passed an order, suo motu, that these persons will be called for cross-examination and thereafter the parties will be heard. So natural justice are always gone into by the commission. And of course, there are certain lapses, not only at the part of the DG, but also at the part of the commission. These can be remedied, either in the writ jurisdiction or in the appellate court. But by and large, the parties are given full hearing as and when the report is received by the commission. And in fact, in 80% of the cases, request for cross-examination is made, and wherever there is even a doubt whether this can prejudice this person or not, the right of cross-examination is allowed. So, for me, I would say that it cannot be said in this before the regulator or before the DG that the right of cross-examination is implicit, particularly seeing the scheme of the Act and the regulation.
Yeah, Dr. Stanley, I think, wants to add something to it.
Yeah, thank you very much. What I would like to add is indeed that since cartels, as I said, tend to be more and more paperless, the key witnesses or the key pieces of evidence are the witnesses, and in our system, unfortunately, the lawyers of the leniency applicants are interviewing them and presenting the evidence to the authority. This is clearly not sufficient, so I think it's here in India much more appropriate that CCI apparently has allowed cross-examination in a high number of cases. What we see here in Europe is really that there needs to be improvement in that respect. Also because the classic old-fashioned cartels with lots of paper will more and more disappear, at least in these international cartel cases.
Thank you. Now we throw the discussion open to the House. Anybody would like to add anything? Yes, please. We need a mic. Yeah.
Sir, I'm Anupam Sanghi. Thank you. Sir, I'm Anupam Sanghi. I run a boutique practice on competition law. So my question is to Justice Endlaw, who mentioned about adversarial and inquisitorial systems being two different types. So considering adversarial system is followed by judicial bodies, by courts, and bodies like CCI, regulatory bodies, are essentially inquisitorial, and there's a substantive difference in the way the facts have to come out, because courts would not be responsible for digging out the facts the way an inquisitorial system would be responsible, and that is where the challenge is. And like Dr. Steiner said, that most of it would be paperless, it's all conduct based, so it's not going to be easy to dig out these facts. The parties will not be that interested in sharing all the information, and we do not have the procedures set where natural justice can be pinpointed in at least certain guidelines, and we can go anywhere, just like public policy made so many there were so many cases were delayed just because of intervention of courts on this point on public policy in the arbitration law. So considering that there's a huge difference in an adversarial system versus an inquisitorial system, and in the Sale judgment, Supreme Court has said that they play so many, that CCI plays so many roles, quasi-judicial, including inquisitorial. So considering, of course, they are also adjudicating and they are a quasi-judicial body, they need to follow natural justice. However, how would courts want to harmonize, like rightly said, that there can be endless discussion on this, but if we do not evolve the law, we're not going anywhere, and maybe it will be worse than MRTP. In MRTP, there was no cartel defined, no dominance defined, and here, even after everything is defined, we are not getting anywhere. So, sir, would it be in a way of forming guidelines? The European Commission has very, very detailed guidelines, may be difficult to define everything of that kind. Or would it be, the courts or the appellate tribunal taking the burden of, instead of just setting it aside, which would really suit all the parties, and everybody is really happy that this is not getting involved, because ultimately these are very, very big economic offenses with great penalties, and the people are haven't even started with damages. That's when they will really feel the pinch. So how would the courts want to harmonize, like you said, that there's a need to really harmonize on this point?
See, ideally there should be a consensus. That's what I said. To get over this obstacle, if the consensus does not emerge, then like Arbitration Act continued to be interpreted from 96 till 2016, and now I'm sure for another 10 years, this law will remain the same. So ideally, if a consensus is arrived at to the mutual satisfaction of the parties at the stage of the DG or the Competition Commission, that would be the best, and that can serve as a guideline or a precedent, and over a period of time, it would become a practice which is followed by the Commission. That's what I feel. Yes, please.
Interesting discussion. I wanted to ask Mr. Mittal a question, which I thought really interesting, the point that you raised per the Act, which is just the scheme of the Act. There's there's no natural justice application before the DG stage. And one of the things we complain about in Europe a lot is that the case team, the equivalent of the DG, is essentially king. If you persuade the case team of a particular set of facts, you know that the Commission will green light, the courts will green light. The standard of review as you go up.
I'm not able to read.
Oh, you can't. Oh, it's not switching. Is this better? Yeah. The quality of the review in Europe as you go up past the case team to the Commission and to the courts reduces. And so if it's correct, as you say, sir, that there is no natural justice right before the DG, then what becomes incredibly important is that the review conducted by the CCI and then the courts is at a very granular level. And there should not be the presumption that currently the DG reports have. They should not have that weight. That should just be a presentation of facts to you as a commission, and you should, one of the proposals is that you should conduct, as I know you do in many cases, and reverse many DG reports. The standard of review must increase proportionately with the fact that there is no natural justice rights at the DG level.
Well, I have talked about the statutory provision. Statute doesn't say that the DG should follow the principles of natural justice. But practically, because DG is instrumentality of state, he has to act fairly. So practically, he also follows the principles of natural justice. But at times, it is found that there is a particular witness who ought to have been permitted cross-examination. Whether this cross-examination was asked by the party or maybe that the party even didn't request for cross-examination at that time. So, the commission invites suggestions and objections to the report of the DG, and the party normally points out. In fact, the party would even point out a witness to be cross-examined, doesn't require to be cross-examined. So these are the things which, by and large, are taken care of by the commission. And in many cases, the matter is sent back to the DG for recording the cross-examination. And of late, in some of the cases, so most of the lawyers sitting here must be aware, including Ramji and Rajshekhar, that the commission itself has recorded the cross-examination for speeding up the inquiry and finishing off the case. So instead of remitting the matter back to the DG for the purpose of recording the cross-examination, because again the commission can evaluate the finding of the DG after taking into consideration the cross-examination which has been allowed by the commission. That can, of course, the commission must follow the principles of natural justice. No man can be condemned unheard, and obviously has to act fairly.
Mr. Aditya Narayan, I think you have the longest experience at this forum, including the MRTP. You would like to say something? Yes, I'm sorry. Yeah.
I would like to mention that very often,
I think all of us are quite audible as it is. They have good acoustics.
This question is to Justice Andlaw. You had suggested that in order to have the Competition Act succeed, from a long-term standpoint, it would be necessary that the bar and the bench are able to evolve a robust system which is inclusive of principles of natural justice. My own experience here has been that sometimes there are cases which may be filed which perhaps at the very inception there are certain things which are not verified, and possibly there is a need to cross-examine the witness to find out the correctness of the facts. But since cross-examination is not a matter of right and may not be given, therefore there is a considerable wastage of judicial time. And finally it leads to a situation, the conclusion may be the same. But as far as we are concerned, we feel that as practicing lawyers before the commission, we feel that sometimes this issue needs to be addressed at a very threshold stage. There may be a situation where if cross-examination is permitted at an earlier stage, the outcome by the DG, the outcome could be quite different. And there may not be a 26-1 order, it may result in a 26-2 order. So as far as we are concerned, how does the bar and the bench evolve a system where we have a more robust system, which is, of course, both inquisitorial as well as adversarial, and which also takes into account principles of natural justice?
See, we have to take the formality out of the system. The formality of the court has to be taken out of the system, which we are failing to do from any of the forums and tribunals. There should ideally be hearings before a hearing, pre-chamber hearing as we call it in some jurisdiction, to tell each other to have a frank and fair discussion and see that, look, okay, this way it can be resolved, this is your doubt, this is what I am willing to put forth. The matter can be ended at that stage. And that, as I said, you have to evolve, because this is a business related forum. So we have to, in fact, I hesitated from saying that. What I had noted down is that maybe we need a bar of practitioners. Maybe it should not be called the Competition Law Bar Association, it should be the Competition Law Practitioners Association. I have had experience in 3 arbitrations with the Bombay lawyers. They have technical lawyers, technical people who are unassisted by lawyers in these construction contracts. And I felt handicapped. I had to tell my client that, look, I can't face them. You have to get technical people. And it worked out much better. So maybe we need that common sense kind of a thing, that maybe law, LLB degree is not essential for practicing in this field. We can have agents over a period of years in labor law. If any of you have experience, agents have developed and they are doing a commendable job. That there in any case. So maybe if I shed our band and the black coats, we'll be more amenable to the Commission and DG. That's just one of the things, but can be done. Yes, Mr. Srinivasan.
So, may I quickly add to what my good friend mentioned, following from what the discussions have been. And my fundamental belief is that all of us agree this is an extremely unique position where we have right the CCI, the DG's office, the higher judiciary, the practitioners, all of us together. And I completely endorse and be grateful that the watchers have mentioned that this is an area where we don't need to convince each other. So it is really, the CCI is now tasked with finding from and South Asia, LPG, the High Court had read all of that, saying that what is the difference between an inquiry and what an investigation is. The investigation proceeds on fact finding. Now if the root is bad, the fruit will naturally be bad. So therefore the Commission finds, in my course of experience before the Commission also, I find that the Commission is handicapped sometimes because it does not find that there has been adequate or a robust investigation by the DG, even though there may be instances or there may be an indication. So really speaking, what is it that all of us are trying to do? We're trying to come to the truth of the matter. And therefore it is important that we have the investigation at the fact-finding level very clear. So there is no need for us to have in law saying cross-examination. The DG himself should feel that if I need to find this is the truth, I should be impelled to test the veracity of what statement I'm recording by Mr. A, so that it is rebutted by Mr. B or there is corroborative evidence in some other form. If he doesn't do that task, sometimes because he's constrained by time, he has to go back to the CCI, then he finds, well, let this be now tested at the inquiry stage by the Commission itself, and there'll be lawyers there, even though I don't call lawyers here, and they will thrash it out. And then the Commission now finds, oh my God, we've got questions that this cross-examination has not been done. What do we do? Should we send it back, or should we rely on this incomplete data that we have? And that is the escalating factor. It ultimately goes down and we have a process failure. So therefore, to follow and to submit, in addition to what falls from your Lordship, is this. My suggestion would be that the Commission has the powers of regulation and to frame regulations. This mutual consent business can happen if we were to submit whatever our suggestions are to the Commission. The Commission frames regulations permitting as a formality and as a guidance to the DG also. And that is followed, of course, in a time constraint. It hasn't to be an abuse. A good DG can go ahead and say, I will allow cross-examination, but I won't allow this facility to be abused. And if he's assisted by able lawyers himself at that stage, then the lawyer for the DG would be able to object if there is something that goes on endlessly. And I think that is extremely important. The DG level at this stage, he is not assisted by competent lawyers. And therefore, the effect of the bar would be manifold. Therefore, there will be a bar that represents the interests of not just the CCI, but the DG also. Ultimately, we must make sure that we arrive at the truth. And I suggest that we relook the regulations, and that is within the purview of the CCI. Again, we are happy to assist and make sure that the bar is representing both the CCI as well as the private side. So it is not as if it is anti one or the other. So therefore, in our interest, it is important that ultimately this is done as quickly as possible.
That's right. I think with the presence of Justice Mittal and the DG is here that they'll consider these suggestions. Somebody else wanted yes, please. Yes, certainly.
I just wanted to follow up on Christian's comment about Germany versus EU in terms of access to the file, where you said Germany, everything is open, EU, there's redactions. I think we both have been involved in cases in the EU where there has been a data room where lawyers and economists can actually come in EU cases and see that redacted information. So Christian, from you, I'd be curious to see how that actually has worked in practice, whether there are leaks, whether there's breaches of the contracts that the lawyers and EU economists have to sign. And to the distinguished panelists from India, I'd like to also get their thoughts on how that actually might work in the Indian context.
Thank you very much for this question. There has been a frequent concern that if unredacted information is made available to outside counsel and economic experts, that there would be leaks. But to my experience, this is not happening. First, there could be severe sanctions against outside counsel who breach their confidentiality obligation and who leak information to third parties or to even their client if they're not allowed to. And also, I think there's a common understanding that it is so crucial to get full access to file, or at least largely access to file, so that this in practice does not really happen. And I can only encourage a system where access to file is granted to the largest possible extent, because as I said, the basic principle should be only defense counsel can decide what is useful for their defense. And from that principle, it's clear that defense counsel needs to get access to, ideally everything. There is case law in Germany, for example, that lawyers who disclose confidential information that has been made available to them for the strict purpose of exercise of rights of defense, that they can be punished even criminally. And I think this is deterrent enough.
Yes, please.
My name is Dhanendra Kumar. Am I audible?
Yes, very much.
My name is Dhanendra Kumar, and I happen to be the first chairman of the Competition Commission. I have one or two observations to make. I completely agree with Justice Endlaw's observation that it would be very useful to arrive at some kind of a consensus during the proceedings of the case. And this brings me to the point which I considered earlier, but somehow we didn't have any system, either in our law or in subsequent development of regulations. See, out of the various, let's say about 12 to 14,000 crores worth of fines imposed so far by the CCI, the actual recovery would not have been more than 1% or 2%. The whole thing goes on endlessly in appeals and subsequently. What I feel, and I agree with you here, that if we could draw a leaf from the European Union and FTC and DOJ in America by having some kind of a system of either settlement or commitment in EU and US, and my friends would bear me out. In the case of cartels and antitrust, there is a provision, and it has developed over a period of time, of having a settlement and a commitment. This brings finality to the cases in midstream, and this also helps in correcting the practices in the market and also recovering the amount which has been agreed to, and everybody is happy. So my feeling is that if we try and develop something of that kind, it would help in bringing finality to the cases earlier than what is happening at the moment. What do you feel about it?
I can't agree more with you. In fact, I feel that the Commission should not be looking at headlines of orders passing fines of hundreds or thousands of crores of rupees. The Commission should see its role as to set right the ills in the system and to set in place the procedures by which the ills, all right, even if they have happened in one situation, would not happen in another. So the Commission should be looking at itself slightly different rather than it's not a contributory to the state coffers. It should not be looking at it like this. It should be looking at that what practices it can put into place to ensure that in future such a situation does not arise. And that can happen only if, and I'm sure that once a finding of culpability has been arrived at, the industry itself would see that that kind of thing does not happen. And what, if I understand you correctly, what you are saying is a kind of plea bargaining kind of a thing, situation. That's I think we already overshot by 10 minutes since Mr. Chaudhary and Mr. Billy Moria have not had a word. I would request both of them to sum up.
Thank you. What I said about the taking cue from the discussion, I think an order, consent order, that is what I think Mr. Dhanendra Kumar has been referring to, which we have also quite a number of times from the bar or from us requested that whether or not we can have a regulation to that effect, that the parties have agreed outside and the Commission agrees to that settlement. Unfortunately, we have to then draft the regulation in that manner because currently the regulation 30 of the CCI's regulation says even if the parties want to withdraw from the complaint, the CCI would proceed with the matter. So naturally, we have to tweak our regulations in such a manner so that the settlement, consent orders become a talk of the CCI. It is agreed that it is not a debt recovery tribunal. It is definitely trying to remedy the market distortions. So naturally, we have to harmonize. That is what is, I think, the order of the day. We have to see that the Commission's order and the DG's investigation are in harmony. Even if the parties are willing to settle it outside the court, it must be upheld in appeal. It should not be said to be that the settlement has really gone wrong. So we are in the process of evolution. The regulation making power is with the CCI. It must not supersede the substantive law because that again becomes a problem. So this is, I think, the way forward for us, and it is good that we have discussed all these issues here. And I think we will be taking a takeaway from this, and that would be the best, to my mind, for the CLBA to take it forward. As we said in the inaugural session, there should be some summing up of our discussions for the day, and I think we can do that as part of our summing up.
Thank you, Mr. Chaudhary. Mr. Billy Moria.
So very quickly, as far as confidentiality of information is concerned, I think the controversy is more around what should be afforded the right to keep confidential, not really to, confidential information, even if it is marked as confidential, is made available to all the parties. So that's not really the issue. The issue is how do you decide whether something is confidential or not? As far as cross-examination is concerned, the key issue here is, will the CCI, I understand that, it's arguable whether the DG has to follow rules of natural justice. And again, if you take the example of the CBI as an investigator, or in fact, no other investigator is required to follow the rules of natural justice. But when the report of the CBI comes to the trial court does conduct the cross-examination. Now, the issue really is one of practicalities. Do we want a system where each and every matter must undergo the rigor of a cross-examination, even though it may not be necessary or not be asked for? I don't think so. And that's my own personal view. I know many of you will differ. The limited point I was making is that the test should not be, do you admit or deny? The test really should be, am I in a position to controvert a statement which has become known to me only once I get the DG report. So I get the DG report and I realize that there's a statement. That statement is not backed up by any documentation. And moreover, that statement is made by a party who is adverse to me, or whose commercial interests will lie if I'm found to be in contravention. In that circumstance, almost certainly a cross-examination should be allowed.
Thank you, Mr. Villimoria. So, if I understand correctly, and then I would request the President of the Bar that the outcome of this session or this theme can be, as far as procedure and natural justice is concerned, to a resolve rather than litigate. If the litigation emanating from the proceedings before the Commission is minimized to the procedural aspect, I think it would be beneficial to all concerned, and we would be able to deal with the substantive issues of competition, which at the moment, and antitrust, which at the moment are being kind of deferred, and the fear is they may be deferred endlessly. Thank you very much. Thank you, Justice Mittal. Thank you, Mr. Chaudhary. Thank you, Mr. Villimoria. Thank you, Dr. Steinle. And thank you to the House. I think the participation has been excellent.
So now we have lunch that's on the second floor. So, but since we're a little late, we request that the next session starts at 2 p.m. So, request all of you to be here by 2 p.m. And as regards penalties, I believe the Competition Commission has not been able to recover a lot of money. How about 500 and 1,000 rupee notes?
So thank you very much.